Perfect, sir. Thank you.
Thank you. Thank you for reminding me. I just forgot it. Our objective is to take care of all IP problems along with their development also. For that purpose, we are running a lot of WhatsApp groups, Telegram groups, where we are providing regular updates. We hold a physical meeting quite long back, as on 10th of March 2018 at Scoop Complex, where we invited our NCLAD chairman at that time and Mr. P.P. Chaudhary, the corporate affairs minister also at that time. Our future roadmap is that we would like to expand horizontally also and vertically also. Horizontally, I mean to say is that since we have a national level presence, we would like to have our presence in every DAT city where NCLT NCLT is there. These are around, I think, 25 places is there. And vertically being that, like if we divide our IBC in some parts, like CRIP, personal guarantee, liquidation, voluntary liquidation, disciplinary proceedings, in that way, we'd like to expand vertically also. Our objective is that whosoever passes an IP exam, let he be our member. And this is along with this objective, we'll be moving forward and holding other meetings also. As far as today's program is concerned, we have divided this program into 3 parts. Our first part is that 15-minute session shall be taken by me, whereby I'll be discussing some latest developments and issues of the insolvency professionals. After that, our respected Mr. Anil Goel will be taking 45 minutes analysis of the law of personal guarantors to corporate debtor under IBC 2016 with reference to, it will be a highly technical session, and we be enlightened by his experience, his knowledge. It will be with reference to personal guarantors to corporate debtor with reference to limitations, subrogation, jurisprudence by respected Shri Anil Goel. And after that, we shall have whatever we have discussed it, and whatever we will be doing subsequently also, a panel discussion whereby we have our eminent panelists, Madam Mamta ji, Nilesh ji, Anil ji, and myself also. These are the 2 issues which we are, which I be taking care and starting with it. Latest developments and issues for IPs. Panel discussion on analysis of law of personal guarantors to corporate debtor under IBC 2016 with reference to limitation, subrogation, and jurisprudence. Okay. Since I was supposed to take some recent issues, तो हमारा आज का जो टॉपिक था पर्सनल गंटर्स के ऊपर था ऑन कॉर्पोरेट डेटर. तो जो पर्सनल गंटर्स के जो अभी हम लोगों को काम करते करते रिसेंटली जो कन्फ्लिक्टिंग सिचुएशन या जो एक थोड़ी सी अंडरस्टैंडेबल एक पर्सनल गंटर्स के केसेस को अंडरस्टैंड करने के लिए सिचुएशंस आई हैं, तो मैं जरा briefly उनके बारे में I shall address my audience and my panelists, and लेकिन इनके बारे में जो डिटेल डिस्कशन होगी वो हमारे अनिल जी करेंगे और बाद में फिर हम इसको पैनल डिस्कशन में लेंगे. देखिए सेक्शन 95 एप्लीकेशन, जैसा कि we everybody knows that there are 2 sections, section 94 and section 95. 94 is by the debtor and 95 is by the creditor. सेक्शन 95 की जो एप्लीकेशन आई इसके अंदर कंट्रोवर्सी ये अरोज हुई. फॉर एग्जांपल लेट्स प्रिज्यूम दिस थिंग. I think I need to mute everybody there because some voices coming from the background. Or
আমাদের কাছে একটা ফর্ম আছে ল্যান্ড বাট তার ডেট ইজ the date is not about a short month.
Yeah, I've been able to mute everybody there. I think my voice is clear. In section 95 application, is in the case of, in one of the our case that in case of a person has not given a guarantee, but he is a co-borrower. There's a difference in a person has given a guarantee and he's a co-borrower. Will the co-borrower be covered, be treated as a personal guarantor of the corporate debtor? तो इसका आंसर हमारी एक एनसीएलटी के अंदर केस हुआ था, इंटेक कैपिटल लिमिटेड वर्सेस विपुलकांत उपाध्याय। उसके अंदर एनसीएलटी ने हेल्प करा कि जो को बोरोवर है किसी भी सीडी का, he will also be treated as a guarantor. सेकेंड सिचुएशन अराइज हुई है सेक्शन 96 के अंदर कि बिकॉज सेक्शन 96 के अंदर मोरेटोरियम स्टार्ट्स ऑन फाइलिंग अगेंस्ट डेटर विदाउट प्रोवाइडिंग एन अपॉर्चुनिटी टू हिम। ये सिचुएशन सुप्रीम कोर्ट तक पहुंच गई है और गुरमीत सोधी वर्सेस यूनियन ऑफ इंडिया के केस में ये 29/4/2022 की ही जजमेंट है, whereby Supreme Court has taken cognizance of this fact कि हम लोग जैसे ही एप्लीकेशन फाइल करते हैं, as we know that the moment we file application interim moratorium starts, और जैसे ही हम लोग ये interim moratorium start हो जाता है तो lot of benefits also comes through the grantor and lot of limitations do also come to the grantor. तो उन जो लिमिटेशंस आती हैं उसके बारे में इसके बारे में कहा गया है कि आपने जो आर्टिकल 32 है हमारा, जिसके अकॉर्डिंगली एवरीबॉडी हैज अ राइट टू say something before he is being treated as a guilty, तो उसके बेस पे सुप्रीम कोर्ट ने कहा कि ये जो 96 के अंदर जो इंटरम मोरेटोरियम स्टार्ट हो जाता है ये आर्टिकल 32 को वायलेट करता है। तो इस इन दिस पर्टिकुलर केस जो सब्सिक्वेंट डेवलपमेंट्स होती है, जो सेक्शन 99 के अंदर रिपोर्ट सबमिट करनी होती है, उसके ऊपर सुप्रीम कोर्ट ने रोक लगा दी है। तो ये भी एक बड़ा इंपॉर्टेंट केस है। अनिल जी इसके बारे में बाद में डिस्कस करेंगे और देन वी शैल हैव इट हैज क्रिएटेड अ वेरी बिग कंट्रोवर्सी, लाइक जैसे पर्सनल गंटर के केस में ललित कुमार जैन की तरह कंट्रोवर्सी थी। वो क्या कंट्रोवर्सी है, कैसे है, लेट अनिल जी एनलाइटन अस विद दिस थिंग एंड लेटर ऑन पैनल डिस्कशन के नाम इसको डिटेल में डिस्कस करेंगे। ये भी एक बहुत मटेरियल पॉइंट आज की डेट में अराइज हो गया। Section 98 part to debtor for replacement of RP. When we started doing this practical cases, so we realized that section 98 के अंदर जो debtor है, debtor मीन की जिसके against ये सारी की सारी प्रोसीडिंग स्टार्ट कर रहे हैं हम, जैसे प्रोसीडिंग है, उसके पास पावर है आरपी को रिमूव करने की, which I feel is quite determinantal. अगर हम why it is so determinantal, in fact because first of all जिसके अगेंस्ट हम पावर यानी कि इंसॉल्वेंसी प्रोसीडिंग्स कर रहे हैं उसी के पास ये पावर है हमारे को रिमूव करने की। अगर इतनी ही इंपॉर्टेंट थी ये पावर उसको देना, तो देन व्हाई दिस पावर वाज नॉट गिवन इन द क्रिप्ट। सेक्शन 27 के अंदर जो क्रिप्ट के अंदर आप किसी को रिमूव करना चाहते हैं क्या नाम इसका आरपी को, तो यू रिक्वायर 2/3 ऑफ वोटिंग। और सब्सिक्वेंटली सुप्रीम कोर्ट ने इन द केस ऑफ के श्रीधर वर्सेस इंडियन वर्सेस बैंक एंड अदर में ये भी हेल्ड करा कि इट्स अ कमर्शियल डिसीजन ऑफ सीओसी। व्हाट आई मीन टू से इज दैट कि इवन जब ये पावर दी गई थी क्या नाम इसका सीओसी को भी, तो उसके अंदर भी उन्होंने रिस्ट्रिक्शन लगाई थी कि 2/3 की उनके पास मेजोरिटी होनी चाहिए। ऑन द अदर हैंड इन दिस केस अगर हम देखें तो सीडी के यानी डेटर के पास ब्लैंक पावर है और it will definitely jeopardize the independence of RP whenever we be doing the cases. रीजन इसका बहुत सिंपल है कि हम जिसके केस कर रहे हैं या जिसके केस हम इंसॉल्वेंसी प्रोसीडिंग्स कर रहे हैं वही हमारे को क्या नाम इसका हमारे को रिमूव करने की उसके पास पावर है। उसका क्या जाएगा, वो तो सिंपली एक एप्लीकेशन डाल देगा कोर्ट के अंदर और कोर्ट हमारी जो क्या कहते हैं ये है जो हमारी अपॉइंटमेंट है, जो हमारी प्रोसीडिंग्स हैं या हमारी जो रिपोर्ट है, जब कुछ भी है उसके ऊपर नेगेटिव रिमार्क्स लेके उसको स्टॉप कर देगी। आई फील इट इज अ वेरी बिग हिंड्रेंस एंड परहैप्स बैड इन लॉ। ओके, सेक्शन 103 एंड 104 रजिस्टरिंग ऑफ क्लेम एंड प्रिपरेशन ऑफ लिस्ट ऑफ क्रेडिटर्स। इसके अंदर वी आई कम अक्रॉस अ वेरी यूनिक सिचुएशन। अब देखिए प्रैक्टिकली क्या होता है, प्रैक्टिकली ये होता है कि अगर लेट्स प्रिज्यूम ए थिंग कि एक बैंक है, उसने 700 करोड़ रुपए का लोन दिया एक सीडी को, और ये मान के चलो कि उस सीडी के अगेंस्ट 7 ही गारंटर हैं, तो अब सिचुएशन क्वेश्चन ये राइज होगा कि जब पर्सनल गारंटर्स के अगेंस्ट उन्होंने गारंटी रिवोक कर दी एंड दे बिकम द डेटर टू द लेंडर, इन दैट केस वो अपना जो क्लेम है 700 करोड़ रुपए का ईच इंडिविजुअल को फाइल करेगा या 100 करोड़ रुपीज का 7 बंदों को फाइल करेगा। तो ये भी एक, जब इसका हम कॉलरी देखे कॉन्ट्रैक्ट के अंदर, उसके अंदर कुछ और आता है, और जो हमारी एनसीएलटी की या डीआरटी की प्रोसीडिंग्स है, जो सरफासी एक्ट की प्रोसीडिंग्स है, उनके अंदर ये सिचुएशन का आंसर डिफरेंट वे से दिया गया है। तो अनिल जी के साथ मिलके और फिर बाद में पैनल डिस्कशन के अंदर इसको डिटेल के अंदर करेंगे कि ये भी एक यानी कि प्रैक्टिकल सिचुएशन जो आ रही है, जैसे मैंने सेक्शन 143 कॉन्ट्रैक्ट का कहा। हाँ, इसको मैंने ना थोड़ा सा एनालाइज करना चाहा कि ये कंटीजेंट लायबिलिटी कह लो या कंटीजेंट एसेट्स कह लो, विद रेफरेंस टू आर अकाउंटिंग स्टैंडर्ड 29 और इंडिया 37, तो उसके अंदर भी मेरे को इसका कोई प्रॉपर आंसर नहीं मिला, और आईबीसी और के अंदर तो इसका कोई प्रॉपर आंसर है ही नहीं। Okay, those were the technical issues. Now, now we are coming to some other issues also. These are the issues जो कि हमारे को absolutely यानी कि हमारे साथ रिलेट करते हैं। उन चीजों को हम लोगों को एज एन आईपी इन टोटलिटी हम लोगों ने एसोसिएशन के थ्रू या अदरवाइज सब लोग मिलके हमारे को ये इश्यूज को एड्रेस करना है आज ही डेट में, बिकॉज सिंस इट इज आवर फर्स्ट मीटिंग एंड वी इंटेंड टू हैव मीटिंग आफ्टर ऑन एवरी फोर्टनाइट बेसिस ऑन एवरी सेकंड एंड फोर्थ सैटरडे। तो नेक्स्ट में जैसे मीटिंग हमारी सेकंड की होगी, सेकंड सैटरडे के अंदर होगी। तो ये एक थॉट प्रोसेस में हम सब लोगों के साथ शेयर कर रहे हैं, और कल रात को मेरी अनिल जी के साथ, ममता जी के साथ और नीलेश जी के साथ काफी डिटेल में इसके ऊपर बात हुई थी कि सबसे बड़ा इस समय जो हिंड्रेंस आ रही है वो ये आ रही है कि हम लोगों का आईपीएस का इमेज बहुत ज्यादा नेगेटिव हो रहा है, स्पेशली विद जुडिशरी और विद वी कॉल इट एट आईबीबीआई, एंड हाउ वी नीड टू इम्प्रूव इट। वो कहावत तो ये है कि वंस कॉट ऑलवेज थीफ, और होता ही है कि अगर एक भी आईपी का गलत काम कर लेता है तो ये सोचा था कि सारे ही आईपी ऐसे हैं, जबकि ऐसा बिल्कुल नहीं है। वो हार्डली एनी आउट ऑफ ब्लू मून समबडी डज इधर नोइंगली और नोइंगली समथिंग रॉन्ग, लेकिन उसका जो इल इफेक्ट बहुत ज्यादा हम आईपीएस के ऊपर आ रहा है। तो इसका जो सोल्यूशन जो है, जो सर से डिस्कस करके हमारा हुआ अदर पैनल से डिस्कस, उनका यही आया कि हम लोग एक रेगुलर मीटिंग्स रखेंगे एनसीईआरटी जजेस के साथ, आईबीबीआई ऑफिशियल्स के साथ, एंड अब्रेस देम आल्सो कि हमारी क्या लिमिटेशंस हैं, हम किन सर्कमस्टेंसेस के अंदर डिसीजन लेते हैं। जो भी डिसीजन हम लेते हैं एज एन आरपी, वो उसके अंदर 3 या 4 स्टेक होल्डर्स होते हैं, और तीनों चारों स्टेक होल्डर्स दे आर द 4 कॉर्नर्स ऑफ एनी डायमेंशन। तो वो हर बंदा अपने इंटरेस्ट की बात करता है, और जब किसी एक का भी इंटरेस्ट हम किसी भी कारण से सेक्रीफाइस करते हैं या उसको ओवररूल करते हैं, तो ही गोज अगेंस्ट अस। तो दिस वी नीड टू टेल देम कि इसका बेस्ट एग्जांपल है होम बायर्स। होम बायर्स को सेटिस्फाई करना इन आर क्रिप्ट इज बिल्कुल ही जिसको कहते हैं ना टेढ़ी खीर है। सेकंड, हमारी जो ये हमारी एसोसिएशन की तरफ से, जो आईपीएस की तरफ से आ रहा है, वर्क डिस्ट्रीब्यूशन। वर्क डिस्ट्रीब्यूशन के अंदर सबसे बड़ा एक मेरा हमारी एक रिक्वेस्ट है, हमारी एक हम्बल सबमिशन है आईबीबीआई को, बिकॉज दे आर आवर पेरेंट बॉडी एंड वी हैव अ ग्रेट रिस्पेक्ट फॉर देम, कि इनका जो सिस्टम है पैनल करने का, ये एक आईपी को अगर 1 साल के अंदर हम उसको 2 पार्ट में डिवाइड करें तो 6 महीने के लिए एक करते हैं, दूसरे 6 महीने के लिए वो उसको पैनल नहीं करते। तो ये इनका जो सिस्टम है, दे नीड टू करेक्ट इट। इनफैक्ट आई हैव बीन पर्सनली फॉलोइंग दिस थिंग टू देम फॉर द लास्ट 2 इयर्स। दे ऑलवेज से कि हम नेक्स्ट 6 मंथ्स के अंदर इसका करेक्शन कर देंगे। एज यू पीपल मस्ट बी अवेयर ऑफ इट कि वो एएफए अगर आपका पूरे 6 महीने के पीरियड का नहीं है तो आपको उस पीरियड के लिए वो पैनल नहीं करते। तो वी विशफुली, अब जून आ गया है, जून के अंदर फिर अब नया पैनलमेंट 1 जुलाई से स्टार्ट हो जाएगा, और 10-15 दिन के अंदर इनकी एडवर्टाइजमेंट आ जाएगी। वी रिक्वेस्ट ऑन बिहाफ ऑफ ऑल आईपीएस कि बीबीआई should consider this thing. Now, most of the work, अगर हमारा कोई काम आ रहा था, मैक्सिमम वर्क आज के दिन में बैंक पैनल से आ रहा है। जो बैंक पैनल से हमारा काम आ रहा है तो उसके अंदर होलिस्टिकली दे आर अलॉटिंग वर्क टू L1 बीइंग जिसकी लोएस्ट बिड आती है। तो वी रिक्वेस्ट एंड वी वांट कि जो ये L1 का क्राइटेरिया है, इट शुड बी रीलुक्ड आल्सो। और इनफैक्ट हम भी जब ये क्या कहते हैं बिडर्स को डिसाइड करते हैं, आरए को एक्सेप्ट करते हैं, तो इन दैट केस We also go for some sort of Swiss challenge method and other methods also. तो L1 का जो criteria that need to be regrouped. प्राइवेट, अब देखिए उसका फर्क क्या रहा है, सेम काम के लिए जो बैंक से हमारे को रेम्युनरेशन मिलता है या जो प्राइवेट क्लाइंट से रेम्युनरेशन मिलता है, उसके अंदर 3 से 4 गुना का फर्क आना शुरू हो गया है. तो दैट नीड टू बी रीरूट बाय अथॉरिटीज. Another is, fees issue. Fees issue is a very grave issue. यहाँ पे तो पहले आप काम कर लो. There are many instances. आपकी statutory responsibility होती है. Statutory responsibility होती है, आपको पेपर में ऐड देना है. आपको you have to hold video conferencing. You have to run the CD as a going concern. उसके लिए आपकी फीस की बात तो दूर, आप अपनी जेब से पैसे खर्च कर देते हो. और डिस्पाइट many court orders, डिस्पाइट मेनी जो एप्लीकेशन जो जिस समय एडमिट होती है, उसके अंदर में लिख दिया जाता है कि आप आरपी को जो एप्लीकेंट है वो ये लाख रुपया, 2 लाख रुपया, 3 लाख रुपया, 4 लाख रुपया देगा. उसके बावजूद भी मेनी अ टाइम आरपी को पैसे नहीं मिलते. और दूसरा जो मेन फीस इशू की दिक्कत है, वो फीस इशू की तो बहुत बड़ी दिक्कत है कि ये इसके लिए हम लोगों ने इंटरनली डिस्कशन करी थी. तो हम लोग वी आर कमिंग आउट विद वन सोल्यूशन कि ये जो है, जैसे हमारे सीए प्रोफेशन के अंदर हमारे को ब्रांच के बैंक ऑडिट्स मिलते हैं. उसके अंदर 2-3 तरह का कैटेगराइजेशन है. कि एक कैटेगराइजेशन है कि branches has been categorized based on the advances or deposits. On the other side, second categorization of CA firms का है कि जो कि categorize करी जाती हैं category 1, 2, 3, 4 based on their experience, number of partners or something like that. तो इस तरह का अगर हम लोग suggest कर पाए इनको, जब वो एक standardize कर पाए accordingly कि इस तरह के जो grid के अंदर किस तरह की फीस कैसे मिलेगी, तो I think that will be a real help to everybody. Or but at the same time, IBA is quite adamant on it. The IBA is very clearly saying, IBA is very clearly saying कि we have left it to the market forces. And many a time judiciary pronouncements इसके ऊपर होती है, और especially अभी जो सुप्रीम कोर्ट ने लेटेस्ट जजमेंट के अंदर कहा कि आरपी की फीस रिट्रोस्पेक्टिवली आप क्या कहते हैं चेंज कर सकते हो. वो चेंज करने का मतलब होता है कम ही कर लो. तो वो कम करने का जो पावर और सीओसी के पास आ गई है, दैट इज अगेन हिटिंग अस अ लॉट. दैट इज अगेन वरिंग अस लॉट. अब another thing is that कि जैसे IP hours करने के लिए we have to compulsorily take some attend some seminars by agencies like IC Insolvency Agency Project, some other ICS Agency Project और ICMA प्रोजेक्ट से करते हैं. इनका बेसिक ऑब्जेक्टिव तो है क्या नाम इसका, हमारे को एजुकेट करना, फॉर विच यू आर पेइंग देम एनुअल फीस. बट डिस्पाइट दैट थिंग दे आर चार्जिंग वेरी एक्सोर्बिटेंट फीस, जो कि हम लोग तो चलो सीनियर है, वी कैन लुक इनटू इट. बट जो जूनियर बनके आते हैं जिनके पास कोई काम नहीं होता, तो वो तो कहते हैं जी हमारे को ये इस पर्टिकुलर, अगर आपके पास सीपी आवर्स नहीं होंगे तो आपको हो सकता है आने वाले टाइम में एफए मिलने में सेक्शन मिल जाए, आपके ऊपर कुछ और लिमिटेशन लगा दी जाए IBI. तो कहते हैं जी इस डिग्री से काम मिले जाना मिले, लेकिन इसको मेंटेन करने के लिए वी हैव टू इनकर सम कॉस्ट. बट एट द सेम टाइम वी सी ये कोरोना के बाद बहुत सारे वेबिनार्स हो रहे थे. इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट भी ले रही थी, NIRC भी ले रहा था, सेंट्रल एंड रीजनल काउंसिल भी ले रहा था, एंड दे वर ऑल दे वर एबल टू मैनेज इट, डू इट ऑल फ्री ऑफ कॉस्ट. देन व्हाई आर एजेंसीज कांट डू इट फॉर IPs फ्री ऑफ कॉस्ट? Another worrying factor is of multiplicity of reporting. अब इसके अंदर we need to report same issue to the adjudicating authority also, many a times agency also, IBBI also, COC also, and अगर कोई गवर्नमेंट एजेंसी किसी भी कारण से इसके अंदर इन्वॉल्व हो जाती है, वो CBI या anything else, you need to report to them also. और ये इसके साथ कुछ रिपोर्टिंग जो हमारी है वो इवेंट बेस्ड है, हाफ ईयरली है, मंथली है. What we request or in fact we can suggest to them also कि कुछ एक इस तरह सा प्रोग्राम वगैरह बना दिया जाए जिससे कि अंदर हम एक बारी डाटा फीड करें और जिन जिन एजेंसीज को जाना है उसके अंदर स्प्लिट होके चला जाए, instead of we have the multiplicity of reportings. I think this is my last point, disciplinary mechanism. आप कोई भी काम कर लीजिए उसके अंदर प्रोसीजरल लैप्सेस तो हो ही जाते हैं, एंड वी आर सीइंग इट फर्स्ट टाइम दैट आर जस्ट टू मेंटेन द स्टैंडर्ड ऑफ IPs कि अगर हमारे यहाँ पे कोई प्रोसीजरल लैप्सेस भी होते हैं तो we are being penalized very heavily, especially by removement either for a month or 2 months or something like that. So we pray our regulator कि थोड़ा सा have a mercy on us and treated us like your younger brother or your sons and daughters कि हम लोग शायद गलती करेंगे तो आप लोगों को थोड़ा सा उसको बड़ेपन की तरह उस गलती को रिमूव करना चाहिए. And recently I heard that some prosecution cases are also being filed. Just see the fate of this profession. Will all this limitation you ever be able to attract good skilled person there or not? अगर हम on the average देखें तो average age of जो IP की है वो 50 years के आसपास की है. Meaning thereby that he is already very experienced and he is already highly educated. तो वो अगर उसके against prosecution launch होना जब different way से कुछ होना, that will be really crippling. This is all. Thank you very much. Now, I be requesting Shri Anil Goel ji to start his deliberation.
Thank you very much, Manoj ji. Thank you very much. And my greetings to all my colleagues, Mamta ji, Nilesh, Sharma ji. So I think I think you have already set the kind of target with me. Like I have to discuss various issues that you have raised, like the application, admission, Gurmeet Sodhi, and whether they are co-borrowers or also PG, and then claim verification. So all this, like we would, because see, we are only having 45 minutes, so we may even extend it. But then yes, then I'll just have to open door. Give me a second, please.
पानी दे देना, ग्लास होगा बड़ा.
So I'm in a hotel. So they just came for setting up some tables without understanding that it is a serious issue going on. And so let me share my PPT. I'm only trying to say that this is the I will not go by clause by clause. We will only discuss the issues which are really concerning the individual insolvency. There are a lot of professional colleagues. They are also suffering. There are a lot of anomalies regarding fixation of fee, when the fees will start, how much is the fees, all this is, and who is going to pay. All this is the kind of discussions, and we need some kind of solution for all this. Just sharing my screen. Give me a second. So I hope it is visible to all.
Yes, sir, it is visible.
Great. So like we'll start with very briefly from this notification. The notification in fact came on this was it was effective from 1st of December 2019, and the notification was dated 15th of November 2019. Why I'm starting from notification was this notification 4126E. This actually has some other issues also, which is very, very important. Although these sections were notified, but the most important part is that section 249 was also notified in this notification. Now, what is written in the section 249? When this IBC code was made, section 249 was also made at that time. So it was also a future-looking code, and nobody knew that after about three and a half years, this would be done, and that was decided somewhere in May, June 2016. So when this section 249 was also notified, the name of that act, which was the recovery debt, and then that was the recovery of debt due to banks and financial institutions Act 1993. The name of this particular act was changed within this notification, and now the name, with effect from 1st day of December 2019, the name is the Recovery of Debt and Bankruptcy Act 1993. Now, Section 249 was made somewhere in May, June 2016 and notified now. And it is also in the same Section 249, it is also there that the government to set up requisite debt recovery tribunals, and also government to set up requisite debt recovery appellate tribunals. It is mentioned in Section 249 that the tribunal shall have circuit sittings in all district headquarters. Of course, this was kind of it was supposed to be coincided with the individual insolvency whenever it was supposed to be implemented. But however, this individual insolvency was bifurcated by adding another clause E, where the personal guarantors were bifurcated from the normal individuals. So this I will actually, because this has got an importance in the jurisdiction part of it. See, presently there is a huge kind of controversy going on whether DRT has jurisdiction or not. I'm personally, in fact, struggling to file an application under Section 94 before Debt Recovery Tribunal. The Debt Recovery Tribunals are refusing it to accept it. They are saying that we haven't got any kind of information. I would remind Nilesh Sharma ji, me and Nilesh Sharma ji, we in fact traveled together to a couple of debt recovery tribunals where we at the instance of Ministry of Finance, at the instance of IBBI, and our objective, the job which was given to us was to train the POs and other staff of the debt recovery tribunals on the personal insolvency. When we visited, they had no information that it is we are also adjudicating authority for this, and even today they are not accepting the applications under Section 94. They are saying that we do not have any jurisdiction under this. So, like, if you see, the name of the act was changed. The kind of section that we see, in case we see this, the section of Section 17 of Debt Recovery and Bankruptcy Act, this was also amended. Section 17 of Debt Recovery and Bankruptcy Act, this was also amended with effect from 1st December 2019. And this particular section says that the jurisdiction would be Debt Recovery Tribunal. Now, when we see this Section 179 of the code, which is subject to 60, the adjudicating authority would be Debt Recovery Tribunal having territorial jurisdiction over the place where the individual debtor actually and voluntarily resides, where carries on business or personally works for gain. So in case the Debt Recovery Tribunal is not having any jurisdiction, then why was this Section 17 of Debt Recovery and Bankruptcy Act was amended? See, what is happening is presently nobody is bringing all these amendments before any court. Like, let us see the amendment which is there in the notification. First of all, somebody should say that the notification 4126 actually also it was notified along with this. This Section 249 was notified. Then it has to be brought to the knowledge of the adjudicating authority or even the NCLAT, and even in some cases Supreme Court, that Section 17 of Debt Recovery and Bankruptcy Act was also changed with effect from 1st December 2019. So the intent was very clear. Intent was very clear that wherever the CIRP or the liquidation process is going on, then the personal guarantor's application will go to the same bench. And in case there is no CIRP or liquidation application pending, then it will go to DRT. It is also very clear that when this application would be admitted, then the case will be transferred from DRT to the Debt Recovery Tribunal. Now let us see this, this Section 60 subsection 2, which also says, I'm reading the any CIRP or liquidation proceedings, any CIRP or liquidation of corporate debtor is pending before any other court or tribunal shall be transferred to bench dealing with CIRP or liquidation of the CD to which, because see why it is say, because the CIRP or liquidation of corporate guarantor and also the personal guarantor, that will be shifted, that will be transferred to the bench dealing with the CIRP or liquidation of the CD to which the corporate guarantor has given the guarantee. So the similarly, insolvency and bankruptcy of personal guarantor shall be transferred to same bench where the CIRP or the liquidation is going on. In case we read section 60, subsection 1, 2, 3, 4, and this is what actually it comes out. This is what actually it comes out. So I think somebody has to argue then only the definition of adjudicating authority. When we see for the purpose of section 60, the NCLT constituted under section 408 of the Companies Act, or in cases other than subclause 1, or in cases other than subclause 1, the DRT established under subsection 1 capital A of section 3 of Recovery of Debt and Bankruptcy Act would be the adjudicating authority. This is the definition of adjudicating authority in this law. So the definition also, in case we have the definition, we have the section 17, we have section 60, subsection 1, 2, 3, 4, and we have also the notification of section 249. Then when all this is done, the only issue is that nobody is bringing before the court, so that there is a confusion for the like the jurisdiction. Now, the other question which is now being raised, I think even Manoj ji has also raised this issue, and that was in fact decided in Lalit Kumar Jain versus Union of India on 21st of May 2021 by Honorable Supreme Court. So 3 things were decided in this particular judgment. One, that there was an argument that under section 133 of the Contract Act 1872, the surety gets discharged, guarantor gets discharged in case there is a variance in the terms of the contract without the consent of the surety or the guarantor. This is what is provided in 133 of the Contract Act 1872, and this was argued before the Honorable Supreme Court in the case of Lalit Kumar Jain. But then the court said this particular argument stands negated, because the section 31 of the code, it makes it very clear that the approved resolution plan is binding on the guarantor. So to avoid any attempt to escape liability under the provisions of the Contract Act 1972, so this was negated. Second issue which was raised and clarified by Honorable Supreme Court, that the sanction of the resolution plan and finality imparted to it by section 31 does not per se operate as a discharge of the guarantor's liability. So the Honorable Court said that as in the nature and extent of the liability, much would depend on the terms of the guarantee itself. However, an involuntary act of the principal debtor leading to loss of security would not absolve a guarantor of its liability. So the third issue which was resolved by this Honorable Supreme Court was that the approval of the resolution plan does not ipso facto discharge a personal guarantor of the CD of his or her liability under the contract of guarantee. So these were the 3 things which were in fact decided by the by Honorable Supreme Court. See, going forward, I am only trying to say that, of course, there are 2 stages of the personal insolvency. See, this particular law that we are reading, we are trying to understand. This is a law which actually would live in the country for years, because it is not the only law for personal guarantors. Whenever personal insolvency would be implemented, this is the law which has been made specifically for individual insolvency, and this will also be applicable for the insolvency of proprietorship concerns and the insolvency of partnership firms. So when we try to understand the insolvency resolution process, it is very important that we should also try to understand the bankruptcy process, because the insolvency resolution process, to my understanding, is not having much importance. It is only an opportunity to settle with the creditors. However, the bankruptcy process is the real process which actually means something. And for any planning, the understanding of the bankruptcy process is very important. Whenever we try to guide a person who is under financial stress, and his personal properties are also mortgaged to secure a loan for a corporate debtor. He is having the SARFAESI proceedings against him. And when we try to protect him, then it is very important that we should discuss with him what is bankruptcy, because the insolvency resolution process will be followed by bankruptcy process. Insolvency resolution process is very simple. It is without any adverse impact on somebody's life, but bankruptcy process may be. So therefore, bankruptcy is very, very important. In fact, I had given, it's a very, very large subject. So I had given 4 webinars on bankruptcy process, all webinars for 1 hour. And I tried to discuss it clause by clause, the pros and cons of going for bankruptcy, how I tried to say that it is a boon for personal guarantors. It is the recovery would be like kind of not much which is expected for the creditors, but the main gain would be for the personal. The main gain is for human. It is a considered of a fresh start of a commercial life for a person who actually has suffered some kind of losses. So the first process is the insolvency resolution process. I will not go into detail. The application can be filed by the personal guarantor. We can call it debtor, and the application can be filed by the creditors also. The applications are like one is section 94 application, the other is section 95 application. We are not going to discuss clause by clause. Application by the creditor also needs a notice, so this is something that we should discuss when we talk about insolvency resolution process or bankruptcy. There are some excluded assets that would not be considered as the estate of the bankrupt. So these excluded assets are unencumbered tools, books, vehicles, and other equipment as are necessary. Now, the word as are necessary to the debtor will actually have a lot of litigation, as probably everyone would understand that the litigation, because see, it's difficult to say what is necessary. Somebody can say that yes, my car which is worth 3 crores of rupees is my necessity, and somebody will say that my scooter is even a luxury for me. So these are kind of the litigation that we see. Similarly, the unencumbered furniture, household equipment, and provisions, these are also, the word written is necessary. Necessary is something which can be adjudicated. See, the most important is the any unencumbered personal ornaments not exceeding a value of 1 lakh. Only 1 lakh ornaments would be excluded. All other would be part of the estate of the bankrupt. However, there is a difference when we talk about other assets. We only talk about the assets owned by the debtor. When we talk about the ornaments, then we talk about the ornaments which is owned by the debtor or his immediate family, and the family and the debtor taken together cannot hold more than 1 lakh of gold ornament, which is important for religious functions. Yes, the life insurance policy without any limit, and the pension plan without any limit. So then I thought, why there is no limit on life insurance policy, why there is no limit on the pension plan. So then I recalled that it is not possible for anyone to take life insurance for unlimited amount. Whenever we take life insurance policy, the profile of the person, the income of the person is seen before somebody can go for that kind of high value insurance policies. Therefore, the government has not put in any limit on the life insurance policies. Dwelling unit for the residence purposes, if urban area 20 lakhs, rural area 10 lakhs of having value, this value would be based on the circle rates, and this would be only out of a home. Maybe the residential house of the debtor is having a value of 2 crores, but he would only be given 20 lakhs and his home would be taken away by the bankruptcy trustee. Similarly, the excluded debts are important to be understood. when we talk about excluded debts, it's the liability to pay fine imposed by a court or tribunal. No, the fine and penalty, these are two different things. Fine is a kind of a result of a prosecution, a criminal default, a criminal offense, whereas the penalty is a kind of a civil offense. So the penalty is covered as a debt which would be waived under the bankruptcy process. However, the fine would not. If any fine is imposed, so somebody asked me a question that as a director, I'm actually some TDS default was there in the company. And because of those TDS defaults, my prosecution has started. And would that be waived? So I gave an answer that no, those would not be waived, because any compounding of the prosecution would also be considered as a fine. So that is something which is an excluded debt and would not be waived under Section 79 of IBC. Similarly, the liability to pay damages for negligence, nuisance, or breach of a statutory, contractual, or other legal obligation. So I'll say a couple of illustrations that I can give internationally. This is very, very important, that if you are driving a car and you are not insured, and if you injure someone, then you would be paying the other person a huge amount as a damages for negligence, or maybe that in case you create some nuisance somewhere, or you create a breach of statutory or contractual or legal obligation. So those kind of damages which can be awarded by a court, those are also not waived, because there are, even in India now, because in case you uninsured car and in case you are hitting someone and somebody die, I think based on the income of the other person who's died, there can be some kind of damages to you, which may even run into 2 crores of rupees in India also. So those damages and all that cannot be waived. Similarly, liability to pay maintenance to any other person under any law for the time being in force. So I think the maintenance which is dealt with in this section is the maintenance to spouse for a divorce cases, maintenance for the children for divorce cases, some maintenance which might have been ordered by a court for the maintenance of old parents. So these are some of the examples of the maintenance. And the loan, student loan, is also not waived. It is also not a part of the debt which would be waived. And the reason for this is because in international market and in India also, nowadays I have seen people taking a loan of 1 crore for doing an MBA in USA, and that loan would be repayable in 15 years. And according to the Indian standards of salary, the 50% of the salary would go into the EMI. So the student, after doing this course, very well understanding that this entire process will take 22 to 24 months, and he would be completely discharged from all the old liabilities. He may even file his insolvency. So that is the reason that this particular debt is also excluded from the debt which can be waived. So some important definitions is only I'm not touching, because the associate is a very, very important definition, because everyone should see who is an associate of an individual, because any transaction with the associate is questionable. I will just see in future. And see the other part is the Section 96 moratorium, interim moratorium. See, like Mr. Anand said, that this is a kind of not really logical. It is not justice to debtors. I would say that this is only to protect the debtor. It is not justified for the creditors. Because see, when you file an application to adjudicating authority, may it be DRT or NCLT, your moratorium starts immediately. And if you read the moratorium is only two-way. Any pending legal action or proceedings in respect of any debt shall be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt. These are the only two moratorium. There is no other moratorium. The individual can still sell his assets. I'm talking about the interim moratorium, not talking about the final moratorium. So means that you file an application and the creditors will sit at home and the debtor will enjoy. If there are multiple personal properties which are mortgaged to bank against the loan which they have granted to the company or LLP, now they are pursuing the SURFACE, they are proceeding against the debtor under SURFACE, when they are trying to come and taking physical possession of the property, they can show that application, that this is the application that I have filed under section 94. So there is a moratorium. So you cannot take any action, you cannot continue any action, no fresh action, no new action, no old action can stay. So this is completely in favor of debtor. It is detrimental to the interest of creditors. In fact, lot of people, they are planning their insolvency in such a manner, they are trying to save themselves from the SURFACE actions against their personal properties, and because the immediate moratorium, and they can sell, because see, nowadays everyone understands that the first requirement is that the notice should be served. Second, notice of the even the first before the appointment of RP, the notice should be served. Secondly, when the section 99 report, then also the debtor should have a say. That means that he also should be allowed to file objections. So how much time it will take even for admitting an application under insolvency? So from filing to admission, I think we have already seen about 7-8 months. So the applications are not being admitted, it is only being filed. So the person is protected, the creditors are suffering. I'm trying to tell you, the person, the debtors are enjoying. They are, in fact, now they are going to the bank. Sir, ये तो application चलती रहेगी, मेरे साथ settlement कर लो, and allow me to sell my asset, because he is able to sell. He is not having any restriction on the sale of the asset. He will settle with the bank, sir, I will sell my asset. You don't sell, I will sell. So he will negotiate with the bank and he will sell the asset, because there is no moratorium on the sale of asset. And section 96 is very clear. Now the application admittance, all this is a process. I'm not going clause by clause. Who can be appointed as a RP? There is only one thing that I wanted to discuss. I think if in an IPE, if a partner was RP on the corporate debtor, he himself cannot be appointed as the RP for the individual personal guarantors. However, his partners can. I could not find anything which restricts the partners of the IPE to act as RP on those cases where the other partner was the RP for the corporate debtor. I could not find any such clause. But however, there is a fear in the market. I mean, there is no such case, but there is a fear in the market, because we should not do this case. Now, this report of the resolution professional under section 99. So what we have seen now, we already have the orders from the court that one, when this application is filed under section 95, there should be, before you appoint the RP, there should be a say of the debtor. That means the debtor should be heard. Second, when the section 99 report is given by the RP, then again he should be heard. He should actually file objections. Although there was no format for this report, but then yes, we have prepared, in fact, some kind of requirements, because see, like I have seen people are working too hard on this section 99 report. It is not required. What is supposed to be done in the section 99 report? RP to comment on all requirements under section 94. Whatever the requirements are, the RP should say that these are the requirements, these are complied with, these are not complied with. Then the RP to comment on the existence of debt and evidences. The debt should not include excluded debt, existence of defaults and evidences, jurisdiction of the application. Then RP to confirm that the debtor is not an undischarged bankrupt, the debtor is not undergoing a fresh start process, the debtor is not undergoing an insolvency resolution process, and the debtor is not undergoing a bankruptcy process. These are the only things that the section 99 report is required. Because I have seen people are going for this asset tracing, and they're doing a lot of hard work on this 99 application, which is not required. Nowhere it is being asked that you have to just be very detailed report. It should be only I think I can even conclude within 4 pages or 5 pages of report as far as the section 99 report is concerned. All these contents of the report is not really important. So the resolution process cost, and who will bear the cost? So when we clearly see, first of all, I could not see anywhere in the code, anywhere in the regulations, even in CIRP, that the CIRP cost will have to be contributed by the creditors. That I could not see. I could not find any section. I could not find any regulation. There are only few judgments which actually says that it should be contributed by the creditors. So it's only based on those judgments. It is a tradition in the market that the CIRP cost has to be contributed by the creditors. Similarly, in this resolution process cost, the fee of the RP, expenses incurred by the RP, fee of the professionals appointed, finance raised for the resolution, all this is considered as the process. This is the definition of resolution process cost. What is mentioned here is that the repayment plan should provide for the resolution process cost and how would it be paid. So it is also mentioned that in case of withdrawal, because there are rules made for the application for the insolvency of personal guarantor rules. In those rules, Rule 11 allows to withdraw the application. So when it is withdrawn, then the applicant will make the payment for the resolution process cost. So it is not really true that it will be. So you can ask your fee from the applicant. Even the applicant can be the debtor himself or the creditor. So they have to pay the fees of the RP. They probably would not say that we will give our own share. It is beyond the law that they will say that we have appointed you, we have given you 50,000 rupees per month, and now the claims have been received from all the 7 banks, and now we will only pay 3,000 rupees and the rest will be paid by the others. That is something which is not provided anywhere in the law. So the applicant will have to pay, and he may collect from others, that is the joint lender forum or whatever. So now coming to the real application, which is now the moratorium starts when the application is admitted. When the application is admitted, and this particular moratorium will end within 180 days, and this application, in this particular moratorium, there is an additional clause, and that is the debtor shall not transfer, alienate, encumber, or dispose of any of the assets or any legal right or beneficial interest. The creditor shall not initiate any legal proceedings in respect of debt. Any pending legal action or proceeding in respect of any debt shall be deemed to have been stayed. So other than these 2 clauses, the 3rd clause has been added that now he will not be able to sell the assets. So in considering the practical experiences today, the filing of the application and the admission, it may take 7, 8 months or 9 months or 10 months. It all depends upon the how many objections come and how the court will take all these objections. So it is actually has become a kind of way out. It has become a way out for all those guarantors who have mortgaged their personal properties. They are making their applications under Section 94 absolutely ready. The moment they see that this application is now that they are taking over the personal possession, the possession of the property, they simply file, take a receipt, and show it to the bank that my moratorium has started. Now you cannot take it. So this is something which is being used in such a manner that nobody can say that it is detrimental to the interest of debtor. It is detrimental to the interest of creditors. Absolutely reverse. So now, once the person is doing this, he has filed an application under Section 94. The application will continue in the court for a year. Somehow he made the bankers frustrated, and the bankers agreed, okay, you sell your own asset, give it to us. So he sells his asset, he give it to the bank, and then he withdraw this under Rule 11. Then he withdraw this, and he avoids the bankruptcy part of it. So it is what we should do as a professional. Like I'm also, because we were also, I was the member of that committee responsible for implementation of personal, implementation of individual insolvency in this country. And we had discussions, multiple meetings and multiple discussions. See, the objective was different. The objective was not recovery. The objective was to provide a fresh start to humans. It was a human angle. It was a social angle. It was humanity. It was not the creditors. So prime focus was humanity. So this is where I think the creditors are presently struggling. They are not able to take the SARFAESI action because everyone is sitting with an application in hand and simply go and file it, and they would the creditors they would suffer. Now the replacement of the resolution professional, section 98. Now, if a RP is trying to blackmail the debtor or the creditor, the debtor and the creditor, if the RP is not functioning, if the RP is not capable, if the RP is doing something which is unlawful, then the debtor and the creditor both can go to adjudicating authority. Your Honor, he is not behaving. He is doing all these non-contraventions. He is asking something which is unreasonable. His fees is unreasonable. So we need to replace him. But both, Anandji, both debtor and creditor, they have no choice. They are not given choice to propose another name. The only thing is the adjudicating authority will see whether their allegations are like kind of acceptable or not. If the allegations are acceptable, the adjudicating authority will pick up another name from the panel. But creditor and debtor both have no option to change the name. I mean, this is again, I would go back to my practical experience. State Bank of India appointed me as the RP for Anil Ambani, and however, the application was filed before without my signature. Now, there is nothing in the law which provides for proposing the name of a RP by the creditor. If you have to propose, the application has to be signed by the RP. In case the application is not signed by the RP, there is no way that you can change the RP. So the RP was picked up from the panel by the adjudicating authority, and the State Bank of India, in fact, is making all the efforts to change it. It is the adjudicating authority says that there is no provision to change it. How can we change it now? There is only one way that it has to be changed. When a repayment plan is proposed, in the repayment plan, there is something which has to be run for another 2-3 years, 1 year, which is the business of the debtor. For that particular running of the business, monitoring of the business, monitoring and kind of the repayment plan, then the creditors have a choice to appoint another RP who actually will implement the repayment plan. But till the repayment plan is approved, there is no way that the creditors can propose another name. That's not there in the law. Public notice, admission on the applications, registration of claims. Now, the registration of claims is a question which is being asked regularly. There are 7 guarantors, and there are 2 banks, and both banks have claim worth 500 crore, and they will file their claim of 500 crores on all the 7 guarantors. So the total claim becomes 3,500 crore, and as against the total liability of the company, which is 700. So the law is very clear that the liability of the guarantors and the liability of the corporate debtor is a concurrent. The creditors can proceed against both simultaneously. However, in case they recover any amount from any of the guarantor, immediately they will have to revise their claim. So it is provided the modification of the claim is required. Modification is required, and whenever they recover any amount, they will change their claim. So the claims are supposed to be filed for all. The claim will be admitted by the RP for the entire amount. RP will only tell them that in case they recover any amount in the process, and then of course the moratorium is there, they cannot recover. But yes, in case they recover by any chance, they will have to revise their claim to a reduced fund. So the list of creditor, there are 3 sources of list of creditors: the information in the application, claims filed and admitted, and the list of creditors to be prepared within 30 days. These are the list of creditors can be prepared. So all this is the most important part would be the statement of affairs, which is supposed to be prepared by the debtor in consultation with the RP. Of course, the asset liabilities, income tax, excluded asset, excluded debts, income statement, income tax returns, the creditors wise detail, all this is part of the statement of affairs, And this is a very, very important document. So once you prepare the statement of affairs, then you can even propose a repayment plan. Repayment plan is important, and in case the repayment plan is filed, in case a repayment plan is submitted, then the RP can say that yes, we can have a meeting of creditors. And in case the first of all, the RP will give a report on the repayment plan, and then the report will be submitted to the creditors in the meeting. In case there is no repayment plan, then the RP can give a report. Since there is no repayment plan, so there is no meeting, there is no requirement of meeting of creditors. There is no requirement of meeting of creditors. That also can be set by the RP. So there may be many cases where there is no repayment plan. So therefore, there may be many cases where all the claims are submitted, list of creditors are made, but there will not be any meeting of the creditors, because it is not required. The meeting of creditor is not required for any other purpose. So that's what it is. The meeting is not required. It is. I have not seen anywhere that even the RP's cost has to be approved by the creditors. I have not seen anywhere that the RP's cost has to be approved by the creditor. It only has to be approved, paid by the applicant. So therefore, I am saying that the fee of the RP, expenses of the RP will be paid by the applicant. He may recover it from his own other consortium members, but for the purpose of RP, the fee will be paid by the applicant. So the meeting is not important. Quorum, summoning of the meeting, contents of the notice, voting in the meeting, rights of the secured creditor, and that's important. Now, section 10.110 says that if there is a creditor who is secured, Anand, please let me know about the timing, because I'm actually trying to rush. Please let me know, because see, this subject is not something that can be covered. But whenever you feel that you can just let me know what is the kind of...
Sir, we are very much eager to listen to you, and we shall definitely extend our timing also. And most probably, whatever you are telling us, as far as our panel discussion is concerned, most of the questions or answers are already being provided by you. And hence, please go ahead as much you want. Mamta ji, what do you say? Sir, please go ahead.
Thank you. Thank you. So this is also a question which is being asked regularly. The secured creditors, like what are the options that they have? Now, the secured creditors have two options when they file their claim. Option one, that the secured creditors forfeits its right to enforce the security interest. And that means that he's actually relinquished the security interest in favor of the in favor of the process of resolution. And he participates in the meeting with the full amount of a claim. And that's what is then whatever is given to him in the repayment plan, that he's satisfied with that. Option two, that the secured creditor submits an affidavit to RP at the meeting, saying that he will participate and vote in the meeting only for unsecured part of the debt. Now, there are two things. One, that the secured creditor will file claim. He is not supposed to take a decision whether he's relinquishing his security interest or not. When a repayment plan is submitted, at that time he will take a decision whether he is participating in the voting or not. If he is participating in the voting for the full amount, that means that he is actually forfeiting his right to proceed against the asset. But in case he gives an affidavit before the meeting that he will only participate to the extent of the unsecured part of the debt. And how the unsecured part and the secured debt, that will be based, there is the basis of calculation, valuation, what is the valuation of the property and what is the total debt. So this is the way. So the claims are not supposed to be submitted along with the relinquishment or not relinquishment. It can be decided by the creditor when the repayment plan is submitted. Before the meeting, it can be done. RP will give a report on the meeting and the approval of the repayment plan by the creditors. Then the adjudicating authority will also approve the repayment plan. Now, this is very, very important, Anandji, Mamtaji, like what kind of effect of the order of the adjudicating authority when a repayment plan is approved. So adjudicating authority may approve or reject the repayment plan based on the report of the creditor as submitted by the RP. Where a meeting is not summoned, the adjudicating authority can pass an order for approval or rejection based on the report of the RP under section 106 on the repayment plan. The adjudicating authority may also give directions for the implementation of the repayment plan. where the adjudicating authority is of the opinion that the repayment plan needs modification, the adjudicating authority can direct the RP to convene a meeting of the creditors for reconsidering the plan. Where the repayment plan is approved, it would be binding on the debtor and all the creditors mentioned in the plan. So this is very important. When the repayment plan is approved, it will be binding on the debtor and all creditors mentioned in the plan. So this is the kind of discharge. So it is not binding on all those creditors who have not submitted their claim. It is not binding on all those creditors who are not there in the repayment plan at all. Then in case
that's a very, very risky proposition. Anil ji.
Yes.
So that person will never get a complete discharge if,
No, that's what I'm saying. This resolution process is actually it's a wastage of time. It's a boon for the personal grunters. The creditors are losing a lot because of this. Although DRT is not accepting so far. This is a dangerous scenario, and whatever I'm telling, it's actually happening. Where a repayment plan is rejected by the adjudicating authority under section 114, the debtor and the creditor shall be entitled to file bankruptcy application. Copy of the order shall be provided to the IBC-IP for entry in the register. So the discharge is only for the for all those implementation and supervision of the resolution plan, completion of the resolution plan, repayment plan coming to end prematurely. So these are all. This is a discharge order under section 119. The RP shall apply to adjudicating authority for discharge order in relation to debts mentioned in the repayment plan. Any debt which is not mentioned, there is no discharge. The repayment plan may provide for early discharge. This is timing issue because see, the repayment plan may even have some clauses which provide for early discharge. Now the discharge under 119 and discharge under section 138. Discharge under section 138 is post bankruptcy. That is something which is significant. Discharge under section 119 is not at all significant. So under section 138, we will see that discharge, that's a complete discharge, other than those debts which has been taken fraudulently. So the order shall not release the bankrupt from any debt incurred by means of fraud or breach of trust to which he is a party. This is also where section 66 applications are in fact filed, and then the discharge probably would not. Wherever CBI or ED is working, those discharge would not be available to the debtors. Now, this undervalued transactions, it's very important to understand because see, everyone is struggling. All the RPs are struggling कि हमें तो avoidance transaction भी करना पड़ेगा, बहुत सारा काम है. So it is very clearly seen in 164 that the RP is not supposed to go for the undervalued transaction or any kind of preferential transaction or any kind of extortionate credit transactions. It is the duty of the bankruptcy trustee, and we only will say BT. So BT who is supposed to do that, not the RP. RP has got no role for the undervalued transaction, preferential transactions, or the because there is no fraudulent transactions here. It is only the undervalued, then it is the preferential transactions, then extortionate credit transactions. So there is no fraudulent under this law. And RP has got no duty to do this. Now let us understand, everyone is cribbing nowadays that we are only getting 50,000 rupees per month and हमारे को पूरा काम करना पड़ रहा है. So what is the work that the RP is supposed to do? RP will sign the application. RP will be appointed and he will prepare a report under section 99. After the report, RP will give public notice and will claim, he will receive claim and he will admit claim. He will prepare a list of creditors. The statement of affairs is a statement of affair is the duty of the debtor. Of course, the RP will work on it. RP will verify it. Then the repayment plan is also supposed to be prepared by the debtor in consultation with the RP. Then there is a report on the repayment plan by the RP, and then the meeting of the creditors, and then submission of a report to the adjudicating authority, and the whatever happens to the resolution plan. As far as the implementation of the repayment plan is concerned, that's a separate assignment. That will be provided in the repayment plan by the debtor. In case there is a repayment plan which goes on 3 years, and the RP is actually being appointed as a supervising and the monitoring agency, then the repayment plan will provide for his fee. So whatever I have spoken, it may take 6 months time or 10 months time, but this is the only job which the RP has to make. There is no control or custody, nothing to take over the bank account, no tracing of assets, no audit of accounts, no perfect transactions, nothing, no responsibility. The responsibility, the kind of preservation and protection of the assets of the debtor, no. To continue the business of the debtor, no. To keep his businesses running, no. To take control and custody of all his assets, no. Tracing of the assets, no. So information memorandum, no. There is nothing as compared to CIRP. कुछ काम नहीं है. 50,000 rupees is also very, very good fee for this much of work. Per month, 50,000 rupees. It's a very, very good fee. If somebody is not understanding the law and simply cribbing, that's not something that we should do. It is the handsome fee, 50,000 rupees a month for all this job. And hardly there will be any repayment plan. I am telling you, nobody is going to submit repayment plan. So moratorium, this is the bankruptcy order. Bankruptcy order will also have moratorium. So now I'm going towards bankruptcy, but that's not required. I think we should end it here. But there are lot many the judicial pronouncements. There are prosecutions. There are lot many judicial pronouncements. So this is Alchemist Asset Reconstruction Company and versus Deepak Puri. In this particular case, like the adjudicating authority, which is NCLT Delhi, has somehow held that in case of a death of the personal guarantor, the proceedings will abate. There are in fact two judgments which says that the death of the personal guarantor, the proceedings will abate. And the second is, this is from NCLT Kolkata, and it is also said that the personal guarantor expired. So therefore, no provision in the code that requires legal heirs to step in to pay dues of the personal guarantor. This is what has been held in these two orders. Whereas in case, I would only say, if we just try to see the bankruptcy part of it, I have another bankruptcy part, and I'm only trying to say that try reading section 169 and section 170 of the code. It is very clearly saying, if a bankrupt dies, the bankruptcy proceedings shall continue as if he were alive. The bankruptcy proceedings shall continue as if he were alive. All the provisions of chapter 5 shall be applicable to the estate of the deceased bankrupt. The claim of legal representative of the bankrupt shall be considered for expenses on funeral and testimony expenditures incurred by, and such claim shall rank pari passu with the secured creditors. Any surplus from the estate of the deceased bankrupt shall be paid to the legal representatives. Now, there are two such orders which is rejecting. Like, see, while you are rejecting, it is not supposed to be rejected. Section 169, 170. See, the bankruptcy proceeding, they should have directed that they should file the bankruptcy proceeding, or what I understand, if this provision is there, then even the legal heir also can file the repayment plan. Because if the legal heirs are not supposed to touch the estate of the deceased, so these two orders are to understanding. Nobody has actually pointed out to them that there is something which is provided in the law.
So, Anilji, so may I just for a minute?
Yes, please.
Which actually then brings us to the point that Alchemist and Divya Jalan orders are actually not in sync with each other.
Absolutely. No, both are saying that there is no provision in the code that requires legal heirs to step in to pay the dues of the personal guarantor. But in the estate, it has to be paid out of the estate, not the legal heirs. It is very clearly written in section 169 and 170 of the code. It has to be paid out of the estate. And if there is an estate, if there are assets, then the legal heirs also can pay a repayment plan. They can also file a repayment plan because they have to save whatever is left in the estate. Now think of a situation that the estate is 100 crore and the debt is only 20 crores. I mean, that means that the legal heirs will submit a repayment plan. So the other part is this is something which is NCLT Mumbai says that the demand notice served on the respondent and the personal guarantor, but no response received. So the issue was that whether the demand notice issued against the corporate debtor under section 7(1) of the code also allows for section 95 application being filed against personal guarantor. So the observations of NCLT Mumbai was, in the absence of any response from the respondent or payment from the personal guarantor is received within 14 days as stipulated by the demand notice, section 95 application may be admitted. Hence, the RP was directed to file the report under section 1999. Simple and not much. However, this NCLAT judgment is in fact important, which says the personal guarantors were provided a copy of the application but were not given the limited notice. So this was the judgment Ramesh Chandra Agarwal versus State Bank of India, where it was held by appellate authority that the personal guarantor they should be given a notice and they should be given an opportunity to file objections. Now, this is the NCLAT judgment where the objections can be filed by the debtor. And now the Supreme Court says that even before the appointment of RP, they should be allowed an opportunity. So this is the Honorable NCLAT held that the personal guarantor should also be given a limited notice to file their objections. Then, whether the default was found before the admission of section 95 application, this was again NCLAT judgment. This was again NCLAT judgment of the April 2022, and it was held that RP under section 99 of the code must file a report first, on the basis of which the section 95 may be admitted. The finding of default must not be treated as acknowledgement of default, but acknowledgement of submission by the applicant. Adjudicating authority must independently consider the question of default. So what was the question? Whether the section 99 report of the RP should find a default? No. To my understanding, the RP is not under duty to find a default. RP is only reporting, and that adjudication about whether it is a default or not, that lies with the adjudicating authority before admitting it as the insolvency. So the issue in this Sandeep Garg and Director Abloom Infotech Private Limited versus DMI Finance, it was an NCLAT judgment in March 22. The issues were whether the financial creditor can invoke multiple remedies by filing claims of the same amount in some other corporate insolvency resolution process, whether a claim still being considered in CIRP of corporate debtor can also be filed against the personal guarantor of the corporate debtor, and it was held the financial creditor can initiate simultaneous proceedings against the corporate debtor and personal guarantor. A personal guarantor took guarantee of the loan amount. Application under section 95 can be filed against them while section 7 application is being considered. So that's also a kind of very well already it has been held. So I think Mutaji, like time to ho gaya hai, because I think we can even go to the question answer and we can even talk about this Gurmeet Sodhi also. The Gurmeet Sodhi is raising constitutionality of section 95 of the code, and which were not really covered under the Lalit Kumar Jain matter. It was basically argued that the appointment of RP without even a notice to the debtor, that was considered as constitutionally not. The notice was given to the Union of India, and the other issue was RP shall not proceed, but this was also this was held in the court. But basically, it's basically on two issues: whether this notice, whether the RP can be appointed right away or not. Now, this Mahinder Kumar Jajodia versus State Bank of India, this is again Supreme Court judgment on 6th of May 22, and it was basically the State Bank of India filed an application under section 95(1) of the code seeking initiation of CIRP, and the NCLT's observation was the application dismissed as premature and observed that no CIRP or liquidation process is pending against the corporate debtor because of the approval of the resolution plan as on date. Section 60 subsection 2 of the code requires that for a CIRP to be initiated against the guarantor, there must be CIRP or liquidation process is pending before the corporate debtor. Before the NCLAT, there were arguments and respondents' arguments Now, the observations of the NCLAT was that Section 60, subsection 2 of the Code does not in any way prohibit filing of the application under Section 99 of the Code, even if no proceedings are pending before NCLT. Then provisions of Section 60, subsection 2 are without prejudice to Section 60, subsection 1 and are supplemental to Section 60, subsection 1 of the Code. Application therefore is fully maintainable. Now, the Supreme Court in this case has said, the Supreme Court has upheld the order of NCLAT. An application under Section 95 of the Code can be filed against personal guarantor of the corporate debtor before NCLT, even in the absence of any pending CIRP or liquidation proceeding against the corporate debtor before such NCLT. Now, this is the kind of, I have other issues where I'm saying that this is a bone. I'm in fact telling it all of you. Now, like now the Supreme Court has said in this Jadogia order that the jurisdiction lies with NCLT. What I'm trying to say that nobody has presented before the Supreme Court the amendment to Section 17 of Debt Recovery and Bankruptcy Act, the notification, and where the Section 249 was also notified. Nobody has brought to the knowledge of Supreme Court. Otherwise, the intent was very clear. Nilesh ji, you were also there, and we trained the presiding officers. And the intent of the government was very clear that this part of the personal guarantors insolvency will go to the DRT. I think now we can start this question answer, and also we can even in the panel discussion, although the time actually has gone up, but this issue was important, so I continued. I tried to finish as early as possible. Yes, Manoj ji.
Thank you very much, sir. We've been enlightened as always कि आपका लेक्चर चाहे कि उसी सेम टॉपिक पे 4 बजे सुन लो या 5 बजे सुन लो, हमेशा ये लगता है कि वी आर एबल टू ऐड समथिंग इन आवर नॉलेज एंड और एपेटाइट भी खत्म नहीं होती. फिर लगता है यार एक बारी नेक्स्ट टाइम में जहां पे आप लेक्चर दे रहे हो उसको हम दोबारा सुन लें. तो दिस इज द यू नो कृष्णा यू कैरी विद योर लेक्चर्स एंड हम लोगों को सिखाने में एंड एनलाइटन करने में. सर हमारे ना टॉपिक के अंदर 3 पॉइंट्स थे. तो 3 पॉइंट्स थे. एक सब्रोगेशन भी हमने काफी लेवल तक पूरा कर लिया, ज्यूरिस्प्रूडेंस भी काफी लेवल तक हमने उसको कवर कर लिया. लिमिटेशन के ऊपर सर थोड़ा सा शायद हम लोग इतना यू नो वी कुड नॉट एनलाइटन इट. इनफैक्ट चार्टबैस के अंदर ही हमारे पास एक मिस्टर रवि शंकर जी का क्वेश्चन आया हुआ है. तो नीलेश जी आप प्लीज थोड़ा सा लिमिटेशन पे, या अनिल जी आप थोड़ा सा लिमिटेशन पे enlighten करें, then we can have our panel discussion and also have 2-3 points which I shall share later on.
Manoj ji, as far as the limitation is concerned, see, there are 2 requirements for an application under Section 95. One, that there should be a guarantee to secure a debt. Then that particular debt is in default, and then the creditor has invoked the personal guarantee. After invocation, the notice has been given to the personal guarantor for payment. That is the notice of demand. So after 30 days from the notice of demand, then my period starts. And if the application under Section 95 is filed after 3 years of this notice of demand, then it is barred by limitation. So it is not related to the debt. It is not related to the NPA. It is NPA of the loan given to the corporate debtor. It is only and only related to the first of all, when was the guarantee invoked? And that's a separate issue whether the invocation was right or wrong. But when was the guarantee was invoked rightly? Notice of demand was given to the guarantor. That remained unpaid. That's a default. So that is a basically cause of that's an event which is to be counted, and after 3 years then it will be barred by limitation. So it has got nothing to do with the date of NPA, the date of filing of the application by the creditor against the corporate debtor. That has got nothing to do with this. This is what is the limitation for personal guarantors.
Correct. So as Anil ji has rightly said, that from the date of default by the guarantor, the limitation starts against the guarantor. So it is not from the date when that account becomes NPA, account of the CD becomes NPA, or the date when the CD has committed a default. So that is not relevant. So CD against the CD limitation starts from the day when he commits a default. and 3 years time period after that is available. For invocation of guarantee also, 3 years time period is available. When the debt is alive, against the principal debtor. So when limitation starts from the against the corporate debtor, within 3 years time period, you can invoke the guarantee. And when you invoke the guarantee, and invocation of guarantee, all we know that invocation means making a demand against the guarantor. So we ask the guarantor to make the payment. We issue that notice to him that principal debtor has defaulted. So now we are invoking the guarantee. You make the payment within a period of time, which is specified normally in the guarantee deed. So if 15 days time period is mentioned in the guarantee deed, then we say that, okay, make payment within a period of 15 days. And when he defaults, then limitation period starts against the guarantor. And then this was upheld. This was held by Honorable Supreme Court in the matter of Syndicate Bank versus Chenna Veerappa Belleri. So there they clearly said that when guarantor defaults, then only limitation starts. Second is the recent judgment of Honorable Supreme Court in the matter of Lakshmipat Surana. So there the effect of admission or effect of acknowledgement of the debt. So affect the acknowledgement of debt by the debtor or by the guarantor has the effect of, provided the limitation period is still alive. So then during the limitation period, if you acknowledge the debt, then with effect from the date of acknowledgement, your limitation starts afresh. So 3 years time period is available after that. So this is the law which has been clarified by Anilji. I think Anilji, we are having most of the questions you have covered, but I think 1 or 2 questions are still there. Let's see your views and the views of other panelists also. I'm having one question for Mamta ji. Mamta ji, you are aware that we are having that judgment of Vishnu Kumar Agarwal versus Piramal Enterprises. Right. So Honorable NCLAT was of the view that for a same amount of debt and default, you cannot get the insolvency resolution process admitted against 2 entities. One, the corporate debtor or principal debtor, and a guarantor. So if based on a particular set of default, particular set of debt and default, you have initiated or your application has been admitted. Your application has been admitted for initiation of CARP. Then your another application which has been filed against another guarantor, that cannot be admitted. What is the status of that view of NCLAT? Whether that is still holding good or whether there is any other judgment? Or I think there was one appeal filed before Honorable Supreme Court against the judgment. What is the status of the same?
Thank you for asking this. In my knowledge, appeal against the said order of Honorable NCLAT is actually still pending before the Apex Court. It is still pending before the Honorable Supreme Court. But however, NCLAT, sir, has itself given a contrary view in the Athens judgment. If we see the judgment in the matter of SBI versus Athena Energy Ventures Private Limited, it has if anybody is interested in the citation, it is Company Appeal 80 number 633 of 2020, wherein Honorable NCLAT has held that simultaneous remedy is central to a contract of guarantee, and the creditor can get the insolvency application admitted against the principal debtor and the guarantor simultaneously.
Correct.
This was a very talked about judgment.
Right.
I think a lot of it will depend on how the axis around the Honorable Supreme Court revolves.
Right. So now because Honorable NCLAT itself has taken a contrary view in that Athena Energy Venture judgment, you said. Okay, wonderful. But still, that appeal is still pending before Honorable Supreme Court. Okay, thank you, Mamta ji. Then Anil ji, this particular judgment of Mahinder Kumar Jajodia. So NCLAT and then Honorable NCLAT in that particular judgment, they interpreted the provisions of Section 60, Subsection 1 and 60 and Subsection 2 also. And they say that Section 60, Subsection 1 is very clear. It says that jurisdiction over the matters of over the insolvency and bankruptcy of individual guarantors will be with NCLT only. And then 60 subsection 2 says that if an application with respect to a corporate debtor, whether it is CIRP or liquidation, if those proceedings are pending against a corporate debtor before a particular bench of NCLT, then the application against for initiation of insolvency process against the guarantor will be going to the same bench. So they say that it is not necessary now that there has to be pendency of insolvency resolution process or liquidation, and then only then NCLT will be having jurisdiction. So they say that NCLT will be having jurisdiction over all the guarantors cases, whether personal guarantors, corporate guarantors, and only with respect to those guarantors who are not guarantors who have not given guarantees to the corporates in respect of the corporates or the other classes of individuals, their cases only will be going to the DRTs. And then Supreme Court also has upheld the same, they dismissed the appeal which was filed against this particular order. You still feel that there is a scope that the jurisdiction of DRTs can be restored again in their favor in respect of the matters of individual guarantors to CD?
See, like my belief is only because of three things. One, the notification of Section 249 and the change of the name of the act, because that was also related to bankruptcy. So in case the DRT is not an adjudicating authority for any of the insolvency matters, then what was the reason for changing the name of the act? Secondly, the amendment to Section 17 of the DRB Act, and that was also along with the same notification. So the intent of the government can be very well seen. See, like the question is, there can be, up to my understanding, there can be 10,000 cases in the country where the DRT proceedings are continuing. The banks have already taken away the properties of the corporate debtor, but the personal guarantees are still outstanding. And there are cases in DRTs, various DRTs in the country, which is basically the case against the guarantors. And then the entire DRT is working against those guarantors, and they are taking the inventory of their personal assets, and then the recovery certificates are being issued. The assets are being there is a restraint on the sale of the assets. All these kind of things are going on in DRT. So that means all those cases, if they have to just protect themselves or they have to just go for the bankruptcy, so that means it will come to NCLT, although the NCLT has got no clue whatever has happened in the past 10 years or 20 years since the SURFACI Act. So the government was trying to say that there may be thousands of cases, because my understanding is that there may be 10,000 cases where the personal guarantors are being proceeded against in various DRTs. For all those personal guarantors, if you feel that this NCLT is the jurisdiction, that was never the intent of the lawmakers. So somebody has to argue, somebody has to present these amendments before the court, because nobody has presented it in that manner. Everyone is trying to analyze Section 60, subsection 1 and 2 and 3. But nobody is actually going to Section 249 and Section 17 of and also the notification, the objective of the notification. Yeah. It is still to be done. I mean, in case we all understand that there are 10,000 cases where people are struggling and they want fresh start through the bankruptcy process. That was the intent of the lawmakers, that all those people, they should start their business again. They should not remain the defaulter for the rest of their life. That was the intent. But that intent is not getting, that was not the purpose to, otherwise NCLT will actually become overloaded. And that's not they are prepared for.
Definitely.
नीलेश जी, कुछ chat board में question भी हैं, वो भी ले लीजिए आप please.
अच्छा. First of all, Manoj ji, I am having one question for you also. Manoj ji, you are aware that this Gurmeet Sodi judgment or Gurmeet Sodi order is there, wherein Honorable Supreme Court has directed that resolution professional will not be presenting his report before the COC, before the adjudicating authority. So what, according to you, will be the impact on the other matters which are going on before different benches of Honorable NCLT? Whether the NCLTs will be proceeding with the those matters, or on the same plea on which Honorable Supreme Court has granted a kind of stay. So, what is going to happen? Whether on the same ground NCLTs will also decide not to proceed with these individual insolvency cases?
Sir, as far as my experience is concerned and what happened in the past also, Lalit Kumar Jain case is a very live example in that case. Because Lalit Kumar Jain के केस में जैसे ही एक सुप्रीम कोर्ट ने ऑर्डर स्टे दिया, तो सब लोगों ने अपने आप को उनके साथ टैग करवा लिया. As a result of which, everything came to the halt. All the insolvency proceedings against personal guarantors get stopped. अब ये मिस्टर सोदी वाले केस के अंदर जो आप बात कर रहे हैं, it has given a very big room to the guarantor. If he wants that proceeding should not, remain alive or against him, then he can very easily go to the Supreme Court and tag his, tag his case also with this Sodi's case, and definitely he will, in my opinion, definitely will get stay from the proceedings of this insolvency. Number one. Now, second question comes to be there ki whether based on this Mr. Sodi's judgment, whether NCLT will grant stay or not. If we see the precedents of Lalit Kumar Jain's case, then NCLT will definitely start granting stay against this case also. And अब जब तक सुप्रीम कोर्ट इनका डिसीजन नहीं लेती, चाहे वो 6 महीने लग जाए या 1 साल लग जाए, depending on the urgency this see at their end, this insolvency proceedings shall be stayed. और सर इसमें जैसे अनिल कुमार जी ने कहा कि ये एक बहुत ये इंसॉल्वेंसी प्रोसीडिंग्स हैं या ये सेक्शन इसके अंदर जो इंटरम मोरेटोरियम है, ये इसमें ये इट इज फॉर द बेनिफिट ऑफ द ग्रांटर ओनली या डेटर ओनली. आई फुली एग्री विद इट. लेकिन सोदी के केस के अंदर उन्होंने यही प्ली की थी कि जैसे ही हमारे अगेंस्ट इंटरम मोरेटोरियम स्टार्ट हुआ या ये प्रोसीडिंग्स हमारे अगेंस्ट स्टार्ट हुई, so because of insolvency and other tag which is put on our head, we are losing a lot of reputation. And this reputation, Article 32 हमारे को बड़ा clear वैसे ये कहता है कि we should not be declared as culprit until unless we are heard. So this is my answer to your question, sir.
Thank you very much, Manoj ji. Anil ji, I am having one last question for you, and then after that we will be taking questions from the participants. So this question is relating to the right of subrogation. So consider a situation where the creditor is able to recover some dues from the guarantor, and then CRP against the corporate debtor is still going on. So what claim he should file? What claim should the creditor file against the or in the insolvency process of corporate debtor? If suppose total dues are 100 crore and out of which he is able to recover 40 crore. So what should the creditor do? Whether he file a claim for 100 crore or he should file a claim for 60 crore only. And then whether after payment of 40 crore, the guarantor is entitled to file a claim. If suppose bank files a claim for 60 crore, then what will happen to that 40 crore claim? Because corporate debtors, that is total 100 crore. So kindly.
So you see, your first part of the question is while this CIRP is going on, the creditors have recovered say 20% of their debt from the personal guarantors. So they should modify their claim, and they have to modify their claim. Whatever is recovered, that has to be reduced, and for the balance amount, they will definitely file a claim before the RP for the corporate debtor. So there is no doubt about it that they have to modify their claim. Now the second part is now the debtor has already given some amount. I mean the property, everything has been taken away, and those are sold also. Now the guarantor has a right of subrogation under this Indian Contract Act. And that right of subrogation, in case it is submitted to the corporate debtor, I don't have any reason to say that the RP will not admit that, because the resolution plan has not been admitted so far. What you see, your question has been framed in such a manner that everything is happening during CIRP.
Correct.
That means that the resolution plan has not been approved so far. The corporate, the personal guarantor has been proceeded against. His assets has been sold, and he will file the claim to the company as a right of subrogation. Now, my understanding is that the right of subrogation is unsecured. It's an unsecured debt. So the RP should admit it. Now comes to the resolution plan. Now it is up to the resolution applicant to see what to pay, how to pay, and if there is a money available, then the resolution applicant will pay also. Otherwise, the right of subrogation is unsecured debt, and that also depends whether the original debt which was paid by the personal guarantor, if that was an operational debt, then the right of subrogation is also operational. If that was a financial debt, then the right of subrogation is also financial debt. So accordingly, it will be unsecured financial debt, or it will be an unsecured operational debt.
Okay.
And the resolution plan will deal with it.
Okay, so what you are saying is that in case of our example, if 100 crore is the total debt, and then out of which 40 crore is recovered from the guarantor, then the lender or the bank will be filing a claim for 60 crore, and the guarantor will be filing a claim for rupees 40 crore.
Absolutely.
Okay. And then if suppose he is able to, both of them, they are able to recover some money. If suppose a lender is able to recover 40% of the same, and similarly guarantor is also able to recover 40% of the same, that means banker will be getting 24 more, and then guarantor against 40, he is getting
some percentage, yes, same percentage.
Same percentage. So that money which guarantor is recovering, that will be belonging to him only, not to the banker.
See, like not to the banker, because see, the guarantor gets into the shoes of the creditor. So whatever are the rights of the creditor, that guarantor will enjoy. As I'm saying, the resolution applicant has to see what to pay, what not to pay. But if this happens during the CIRP, you see, like there are two separate issues. One, once the resolution plan as approved, Section 31 is applicable. But you see, your question is not involving Section 31. Section 31 is not yet triggered.
Correct.
That will only trigger later on.
After approval of plan, yes.
After the approval of the resolution plan. See, that is very clearly mentioned in Lalit Kumar Jain that it is only because of Section 31. But your question says that the Section 31 has not reached as of now.
Correct.
So I think the personal guarantor steps into the shoes of creditor. And whatever the rights of the creditors are, the same right will actually flow to the personal guarantors.
Yes. But we know that most of our lenders or our bankers, they have a clause in their guarantee deed that the guarantor will not be filing a competing claim. So that is the reason that if guarantor has not recovered its dues fully, then guarantor cannot file. So this is another thing. But as per law, what you are saying is correct, that he steps into the shoes, guarantor steps into the shoes of the creditor to the extent of the money actually paid by him. Thank you very much, Anilji. Let's quickly see what are the queries which have been raised by the participants. One is Mr. Pankaj Gupta, I think. Can bank revoke bank guarantee against any corporate person under IBC, and in which section? Bank guarantee.
I think this is not related to personal insolvency.
Yeah, it is not related.
He's asking a question regarding the invocation of bank guarantee during CIRP.
Correct.
During CIRP.
Correct.
I mean, we can answer that. If we can answer that, the invocation of bank guarantee during CIRP is not prohibited. The issue of bank guarantee is an independent contract between the beneficiary and the bank. So the beneficiary is not restrained from the CIRP or liquidation. So the beneficiary will continue to remain beneficiary even if the CIRP starts or the liquidation starts. He will demand money from the bank in case the bank guarantee is there, because it's a very, very clean contract, very clear contract. No option is given to the banks. There is nothing. They see the beneficiary is not supposed to ask from anyone.
Right.
So he will get the benefit.
So moratorium will not apply to the bank guarantees.
No,
which
it will not. It will not.
Okay.
Unless this bank guarantee is something to recover a debt.
Right.
But
Then
that is also not applicable. That is also bank guarantee is an independent contract,
bank guarantees.
irrespective of the insolvency or liquidation.
Correct. Nidhi Saini's question is, can we file section 95 in NCLT against the co-borrower who is jointly and severally liable as per the loan agreement?
Now, the co-borrower is not a personal guarantor. This this law is only applicable to personal guarantors, not the borrowers. So if an individual has taken loan or has taken a loan jointly with a company, that doesn't mean that he's a guarantor. So there can be two cases. One, that the person is a co-borrower and also has given a guarantee to that part of the loan which is given by the corporate debtor. Now, suppose there is a loan against property, LAP, and in that loan against property, the personal guarantor is a co-borrower for his amount, and he is also granted the amount which is the share of the corporate debtor, if the shares are mentioned in the agreement. Otherwise, the co-borrower is not a personal guarantor, so this law is not applicable to co-borrower.
Thanks. Then Mr. Ravi Shankar's question is, does the right of subrogation available to a guarantor who is a shareholder?
Right of subrogation is available to everyone, irrespective of the shareholder, promoter, director, related party or not. See, the creditor is defined as a creditor, irrespective of being a related party or a shareholder or a creditor or a director. Once a person is a creditor to a company, he can file a claim and he is also eligible. What he is not eligible is to participate into the voting in the COC meeting. Otherwise, he is a creditor and he is entitled to his share under Section 53.
Thank you very much. I think with this,
Nilesh, let me ask one, continue question. Mr. Anil, sir, अभी आपने कहा कि co-borrower किस situation में इस provisions के applicable होगा, किस provision में नहीं applicable होगा. But this matter has to be adjudicated by the at the time of a division of the application, or the adjudicating authority decided based on the papers submitted to them at the time of admission of application. And do RP in their in its subsequent report in Section 99 need to adjudicate this matter or not?
RP is under Section 99 report. RP will definitely provide his own understanding about the agreement, whether this was a guarantee or it was a loan. If it was a loan, individual insolvency is not triggered. If it was a guarantee, the individual insolvency is triggered. And then the RP can give a report that this is not a case where the individual insolvency can be admitted. Adjudicating authority is not the RP. RP is only a fact-finding body, and after finding the facts, RP will provide its report to the adjudicating authority. RP is not adjudicating.
Thank you very much, Anilji. Thank you very much. I think very wonderful presentation, and I think all of our participants must have benefited because of the presentation which has been given by you, and most of the queries which we were having, I think, were already answered by you in your presentation. So over to Manoj, formal thanks to the participants.
सर लास्ट में बस आप एक बात ये बता दीजिए कि सेक्शन 2E तो क्या कहते हैं नोटिफाई हो गया, F और G जो है कि यानी कि म्युनिसिपल पार्टनरशिप फर्म्स एंड इंडिविजुअल, ये एज पर योर बोथ ऑफ योर्स एक्सपीरियंस डीलिंग विद द डिपार्टमेंट, ये एक्सपेक्टेड कब तक है? बिकॉज वी IPs expect a lot of workflow because of notification of these section F and G also to main section 2.
So presently, the government is facing a lot of criticism of the insolvency law. So why this personal guarantor was immediately started? Because see, the government was also getting criticism. Like for all these larger companies, the government was getting criticism that this is going to be a bigger scam, that the government is taking away their company from them. However, the promoters who have caused losses to the creditors, they are still enjoying their life and they are living king size life. So that was something which was hurting government politically, and therefore the government decided that we will make all of them bankrupt. And in August 21, there was a email communication. There was a kind of mandate which was given to the public sector banks to proceed against the personal guarantors. And the government only wanted to make a slogan that we have made all of them as bankrupt. Nothing beyond that we can say. And if somebody is living on somebody else, if somebody is living on somebody else's asset, tomorrow if the Anil Ambani's insolvency happens and he is traveling in a car which is not owned by him, that's a separate issue. But nobody can say in future that Anil Ambani is enjoying and he is living his life, because anyone, like there are many politicians, there are many gurus, there are many babas, they have nothing in their own name, but they're still living king size life. But the government want to say that they are bankrupt. Once they are bankrupt, that means that they had nothing with them as then the bankruptcy concluded. So that's what was the objective. So I don't think there is any hurry to government to start individual insolvency or insolvency of partnership firm or proprietorship firm. That is, I don't think there is any hurry with the government as of now.
Thank you very much. Thank you very much. We as usual, we get enlightened, and I would like to share with the participants that AIIPA is now going to organize these webinars regularly on 2nd or 4th of Saturday. And this was supposed to be held last Saturday, but we could not arrange it. That is why we held it in the first Saturday, in the month of first Saturday, most probably second Saturday or fourth Saturday, as per availability or as per requirement topics. We will be holding this meeting. With this, we thank you very much. So thank you all the participants. Thank you, Mr. Praveen Jain ji. आपने आके बहुत अच्छा लगा, and I'm finding a lot of advocates are also there. Thanks to all the advocates. Mr. Sabe was there, Nidhi is there. Thank you very much. No, we are closing down our webinar. Thanks for participating. अनिल जी बहुत बहुत धन्यवाद आपका, और आपको आगे भी तंग करते रहेंगे हक के साथ, because आप हमारे
लीडर हो,
हमारे
participant Manoj ji, Nilesh ji, Mamta ji, thank you very much all the organization. AIIPA, I think you started doing a wonderful job. It's an old organization, and in fact I wanted that it should be rejuvenated, so you've rightly done that. So thank you for inviting me, and it is my pleasure that I'm sharing my experience and knowledge with all of you. Thank you very much. I enjoyed a lot.
Thank you.
Yeah,
Thanks.
with this note, we are ending our meeting. Thank you very much. Thank you.